Boro Murrumbung, good day. Thank you for joining us this morning on this release event to provide public access to the Kerr Palace Letters. And pleased that those of you from Sydney were able to get through the rain, come down to this lovely Canberra day, lovely winter day. My name is Louise Doyle and my role at the National Archives is Assistant Director General Access and Public Engagement. This event, it's the first on-site function here at the National Office since COVID-19 pandemic restrictions were introduced in the ACT. The event is being held for researchers who have applied for access to these significant records and for representatives of the media. For those who are unable to physically attend today, we are live streaming and filming this event. A recording of today's proceedings will also be uploaded to the National Archives YouTube channel for public viewing later today. Shortly, we will hear from David Fricker, Director General of the National Archives, who will provide a background to the Kerr Palace Letters in context, the High Court judgment, and the National Archives' response to the judgment. The Director General will take questions following his presentation from the floor. So, in advance, please wait for the microphone and identify yourself so that your question is recorded. Do note, all records comprising the Kerr Palace Letters have been digitised and will be released in full from 11 a.m. this morning online via the National Archives database record search on our website naa.gov.au. Detailed descriptions of their contents and the digitalised copies have been loaded to USBs, available for those of you present to collect at the registration desk at the conclusion of this event. A selection of Kerr Palace Letters has been copied for access, and some of you have already had a glimpse of those. Available here in the function room through to 12 noon today for viewing, photographing and for filming. The records contain correspondence, as many of you are aware, from the Palace and various published and non-published attachments, including press clippings and articles. As copyright of this material is not, in all cases, owned by the Commonwealth, you are responsible for seeking the relevant permissions from the copyright owner prior to reproduction. And lastly, we ask that you also acknowledge the National Archives of Australia in the usual way as the source of the records. So please welcome Director General Mr. David Fricker.
Naji Injamali, Nambri, Gulma, Wolgalo, Wolabaloa, Nunawal, Majigang Yanibu, Janju. Dear Nalbang Manager, Gurabari, Mururangalang. I acknowledge the Ngunnawal and the Ngambri, the traditional owners and custodians of the land upon which we meet today, and I acknowledge their continuing connection to land and community. I pay my respects to the people, to their culture, and the elders past and present, and also extend my respects to any First Nations people who are with us today or joining us online. And I welcome everybody here today, either in person or virtually, but either way at a very safe COVID distance. Look, this is a very historic day for us here at the National Archives of Australia, as we do finally come to the crunch now and release these Palace Letters for public access. And at the very outset, I also want to say this is a day that's shared by Professor Jenny Hocking, who took her case all the way to the High Court of Australia and in so doing has brought us to this point. It is a great pity that COVID has intervened and Professor Hocking is unable to be physically present here today. But I assure you that she is online and for this event and has already received, just received a full set of the documents in digital form. And I welcome Alison, her research assistant, who is here to represent Jenny at this event. Now, this is a special event for us today. Of course, it's bread and butter work for the National Archives of Australia to open government records that have previously been withheld from public release. This is fundamental to what we do. It's written into our enabling legislation. We do it every day, and in fact we do it on average about 30,000 times a year. But today's release is something quite unique. It's quite remarkable and worthy of this special event. And so what I'd like to do at this event today is take a few moments to talk about the records themselves, the history of these records and the National Archives, and then to walk through a selection to preview what lies in wait when these documents are released. So, firstly, perhaps I should explain why, as a question I get asked quite a bit, why did it take a High Court decision for you, Director General, National Archives, to release these papers? Surely they're official documents. They should have been released, as were all the other official documents from the 1970s. So let me just briefly, for the record, just restate the position of the archives. From the time that they were deposited with the archives back in 1978, right up until the decision of the High Court on the 29th of May last, these records have been held in a special category under the law. And even when the Archives Act was passed in 1983, there was provision for the distinction between the Governor-General and the official establishment of the Governor-General, and these records were held as non-Commonwealth records, a voluntary deposit with the National Archives under an agreement entered into with Sir John Kerr. Now, under that agreement that we made with Sir John Kerr, the depositor, we were able to make most of his papers available after 30 years, and this was done back in 2011. You will remember that we released private papers of John Kerr, including his journal that he wrote in 1980. These were made publicly available. However, his instructions regarding the Palace Letters required us to release the Palace Letters only with the agreement of the monarch. So it is a point that I like to stress. It was his wish that the Palace had the final word. Now, they were the rules that we were playing by at the National Archives of Australia. And they were the rules that were confirmed by the Federal Court and then the full bench of the Federal Court, that they were not Commonwealth records. And while it was often reported that I or the National Archives had deemed these records to be personal and private, it was in fact impossible for me to take any other course of action given the decision of the full bench of the Federal Court. And as I said all the way through that, and I'll say it again now, we are a pro-disclosure organisation, but we do things according to law. It is not within my powers to act in a manner which is not permitted by the Archives Act. We are, and we must remain, a trusted public institution. When institutions start acting outside the law, public trust, quite rightly, evaporates. Now, all of that is why the High Court decision is so remarkable. When the High Court overturned the ruling of the Federal Court and recognised these records of Commonwealth records, it enabled the National Archives to exercise that part of the Archives Act that lawfully makes these records available to the public. Now, I do accept in our role of making records available to the public, we don't always keep up with public demand. As I say, we do release about 20,000 records a year, but we get 40,000 requests a year. If we had more resources, we'd do more. But in the real world, of finite resources, we do all that we can. But look, let me just return, while I mentioned that High Court decision, I really do again acknowledge the perseverance and dedication of Professor Jenny Hocking. And I want to say again on the public record that while for the past few years, for good reasons I think, Jenny and I have been in opposite corners throughout this court case. However, never once have we disagreed on the value of the records or the extent to which they might illuminate the understanding of what is a tumultuous period in Australia's history. And from a personal point of view, I hope that by making these records available to everybody, it will in fact improve Australia's appreciation of its constitution and of our Australian democracy. So let me say publicly what I've already said privately to you, Jenny. Congratulations on your success. And congratulations on the way you achieved your success, using the law, using institutions to achieve the release to the public of government records. And look, while I do mention Jenny and her achievement, I am reminded of the launch back in 2016 of the National Archives' own publication, written by Jenny Hocking, the Gough Whitlam Guide, the Guide to Archives of Australian Prime Ministers for Gough Whitlam. We did commission Professor Hocking to research and write that excellent resource, which was launched by the Honourable John Faulkner. And I just briefly, at that event, John reminded us that it was in fact the Whitlam government that established the National Archives of Australia. And in fact, it was Gough Whitlam in 1975, in October 1975, Gough himself announced that the government would enact legislation to ensure that Australian governments were publicly preserved and accessible to the public. And it was the Whitlam government that appointed the first Director General of the National Archives, Professor Bob Neal. I just think it's interesting to note that the dismissal that we're talking about today also coincided with the initiation of legislation that would, in the end, provide public access to those records. So, what are we going to see in these records? Well, there's a lot of them. I think that's been widely publicised already. Because, of course, we're talking mainly about the dismissal here, but let's not forget there's a few other things going on in Australia during 74 to 77. Throughout his tenure, he provided many explanations and analysis of political developments in Australia. He was a very chatty correspondent. He does detailed state visits. He goes into some Commonwealth-state relations issues, which you won't be surprised we still face today. There's the establishment of the Order of Australia, which, of course, Sir John was deeply involved with. He talks about developments across the public service. Cyclone Tracy, of course. The independence of Papua New Guinea. Remember the discussion about Prince of Wales, Prince Charles, might be the Governor-General of Australia. These things are all illuminated in this correspondence between the Governor-General and Her Majesty the Queen. And, of course, the dismissal. What's in there? Typically, letters several pages long from Sir John, who is just giving a roundup of what's going on in Australia at the time. And in almost every case, he's attached newspaper clippings from the day, which provide that additional analysis for the information of the palace to explore the background to the various achievements. Now, from an archival point of view, it's important to, I think, study the actual clippings that were selected by Sir John, because I think his selection of these and his references to them, I think, also give an indication of his view on what was going on and what he thought the monarch should be aware of. They're all addressed, my dear private secretary, or hers. They're signed, you know, or few letters are addressed directly to the Queen as Her Majesty, and they're generally signed with an assurance of humble duty and respect for the Queen. They're all marked, of course, personal and confidential, or personal in confidence, and sent into the palace. Coming back from Buckingham Palace, letters signed by Martin Charteris, who is the private secretary of the Queen. On a few occasions, there's a press clipping. This one included a press clipping from the UK. And this particular letter deals with the revocation of the Dormant Commission of Sir Colin Hanna after the intervention of the Governor of Queensland in one of the events. So, you know, we have these sort of things, quite lengthy letters going to the palace, letters coming back from the palace to Sir John. I know everybody in the room wants to study every letter I put up, and you will, I promise, but all I want to do today is just give a bit of a preview. Because I'm not a historian. I think everybody should appreciate that. I'm the National Archives of Australia, and archivists should not be historians. We should not stand in the way of an analysis of history. We should provide archives which are the evidence upon which history can be contested. And this history will continue to be contested, I have no doubt. And history should be contested. Around the world, we're seeing people tearing down statues because people don't like just one version of history to exist. We need a world where several histories can coexist. And so these records, these 1,200 pages, and I hope to hell that number is right because I've been quoting that number ever since I opened this box, but certainly when I counted up the PDF files. These 1,200 pages is an archival collection. Read them all, okay? It's all about context. No one document is going to be the single answer to everything. Context is everything. However, that said, today what I want to do is preview just a few documents that will provide some insight into what might be the historical significance of these records. And I've selected just a few here. The first one is from the 12th of September, and so this is a couple of months out from the dismissal, and it's an indication of how Sir John is describing, the contest that's coming, and also there's a paper clipping in there. Now again, historians will want to read this over and over again, but what we start to see here is a discussion of the reserve powers. Did the monarch know that Sir John was looking at the reserve powers and how they might be used? What is he getting advice back from the palace on whether he should or should not use them? So here we see that as early as September, there's some commentary coming in about what his constitutional role should be in relation to a number of matters, leaving it to events determined to what I do. I'm also keeping my mind open as to the constitutional issues. If the Prime Minister and the Leader of the Opposition get into a battle in which the Senate has defeated the budget, the Prime Minister refuses to recommend a dissolution, my role will need some careful thought. So this is for the palace. He's bringing the palace's attention to that. The press clipping he's selected over there on the right, and I've just selected a bit there, which already starts to explore the options of a dismissal by the Governor-General. The newspaper article that is selected describes the Governor-General as guardian of the Constitution, has a choice of either exerting strong pressure on the opposition or to dissolve the lower house himself. And then what would happen? He would have to call upon the Leader of the Opposition to form a government solely for the purpose to dissolve the lower house and call an election. So 12th of September 1975, Sir John is laying this out. Coming back from the palace, a letter is quite polite, things about the Prince Charles and return to Balmoral, etc. But it does, if I can just quickly refer to the written postscript from Martin Charteris, who just sort of quotes back to Sir John. I suppose you know Eugene Forsey was his writer, written a publication, The Prerogative of the Dissolution. I believe it lays it down as a principle that if supply is refused, it always makes it constitutionally proper to grant a dissolution. Now, grant at whose request? At the request of the Prime Minister, at your grant, request of the Queen, who knows? But it's discussed. This is already a topic of discussion between the palace and the Governor-General. Down here, there's much been written about the conversation with Prince Charles at the celebrations to commemorate the independence of Papua New Guinea. And again, there's lots to read in here, and I know every time I put up these, we want to read them all, but if I can go to this is 2nd of October 1975, from Martin Charteris back to Sir John. Prince Charles told me a good deal, and you'd spoken of the possibility of the Prime Minister advising the Queen to terminate your commission. There would be considerable comings and goings, but I think it is right. I should make the point that at the end of the road, the Queen, as a constitutional sovereign, would have no option but to follow the advice of her Prime Minister. So this is, the tension is growing there about, the race to the palace that people often talk about. Let's hope none of these unpleasant possibilities come to pass. I believe more one thinks about them, the less likely they are to happen. The umbrella reign syndrome. So, conversation there. So evidence there that Sir John's own commission had also been the subject of discussion. 17th of October. Again, a lengthy letter, 6 pages of length. 17th of October, it rolls through the issues, the Kemlani, it talks about the deputy, it talks quotes from Hansard, etc. So again, if you'll allow me to pick out a few things. So he commences. As you know by now, the crisis has finally broken. The Liberal Party met over the weekend, gave to Mr Fraser a clear indication the party wanted was for him to deny supply. It then goes on. The position now, that the Prime Minister, in response to Mr Fraser's decision, has decided to tough it out. He may recommend a half-Senate election. The then if we go to the last sentence there, he told me last night he would not be out to Yarralumla on the crisis for some time. So there's clearly growing tensions there, which is being described to the palace. Again, in the same letter, Mr Fraser, on the other hand, though realising, according to his public statement, I cannot be expected to act immediately, takes the view I have ample power before chaos develops too far to dismiss the government and produce an election. He was at my dinner party last night. This was a dinner in honour of the Prime Minister of Malaysia. And, you know, Sir John describes him as a very worried man, but he has crossed the Rubicon. This is Mr Fraser he's talking about. And so 2 more quotes from this letter, this 6-page letter. This has been reported, but here we see it now being reported to Her Majesty. Before dinner last night, the Prime Minister, in what he would claim to have been a jocular fashion, said, apropos of the crisis, it could be a question of whether I get to the Queen first for your recall or you get in first with my dismissal. We all laughed. So it's there. And then I think the final paragraph in this letter from Sir John, I've appreciated very much the letters which you've written to me. I do not know what will happen or what I shall end up by doing, but the country is set on a collision course now of historic proportions. So this is the Vice-Regal talking to the monarch. We are on a collision course now of historic proportions. So there's no doubt that Sir John is faithfully reporting the situation, but he's making the point, I don't know what will happen or what I shall end up by doing. This is really fascinating stuff. It's an understatement to say it, but it is. So coming back, on the 4th of November, again discussing the reserve powers. And there's lots to read there about when the reserve powers or the prerogative of the Crown to dissolve Parliament have not been used for many years. It's argued they no longer exist. I do not believe this to be true. I think those powers do exist. Again, if you'll allow me to cut to the final paragraph of this letter from the palace back. Again, with great respect, I think you are playing the vice-regal hand with skill and wisdom. Your situation, your interest in the situation has been demonstrated, and so has your impartiality. The fact you have powers is recognised. But it's also clear you will only use them in the last resort, and then only for constitutional and not for political reasons. I think it's, as I say, I'm not the historian here, I'm just the dumb archivist, but I'm reading some fairly strong messages in there. And apologies to my staff. There's nothing dumb about being I'm a dumb archivist. Archivists in general are highly intelligent people. All right. Then the 5th of November, again, raises another specific point. Sorry, I'll get to this. This was in response to the ABC in Australia contacting the palace to find out, look, is the Queen aware of what's going on? You know, is the Governor-General telling you anything? And there was a public statement issued by the palace back to the ABC. If you'll allow me to just pop out a couple of paragraphs. Sir Martin is saying, I think it's good that people should know the Queen is being informed, but of course this does not mean that she has any wish to intervene, even if she had the constitutional power to do so. The crisis, as you say, has to be worked out in Australia. So this is the palace talking to the Governor-General. And finally, I think this paragraph really stuck with me. It is, of course, true that anything you may do could indirectly affect the monarchy in Australia. This places you in what is an unenviable, but certainly a very honourable position. If you do as you will what the Constitution dictates, you cannot possibly do the monarchy any avoidable harm. The chances are you will do it good. So, back to you, Governor-General. However, I shouldn't make those remarks. There's 1,200 pages in here. Read them. Context is everything. But I think these whet the appetite of researchers who are going to look at these documents in detail. 11th of November. It is a fairly concise letter, 2 pages long. It has several attachments. He's attached to this the letter that he handed to the Prime Minister of telling the Prime Minister he'd been dismissed. It attached his legal opinion from Garfield Barwick, and he attached also a letter which Mr Fraser wrote to Sir John at Sir John's request, upon the basis of which there were attachments to this. But this is the notification to the Palace of the dismissal. So just if I could go to that paragraph, again, what interventions were happening, what role did the monarchy play? I should say I decided to take the step I took without informing the Palace in advance, because under the Constitution, the responsibility is mine. And I was of the opinion it was better for Her Majesty not to know in advance, though it is, of course, my duty to tell her immediately. So this is what we're discovering in these letters today. So quite an important document in an important collection of documents. Coming back, the letter coming back is on the 17th of November, so this is when we receive notes back. And, thank you very much for your letter of the 11th of November, which I, of course, showed to the Queen as soon as possible after it arrived. It also recounts in there that David Smith would have reported to you, Sir John, that Mr Whitlam phoned the Palace at 4:15 a.m. London time on the 11th and prefaced his remarks by saying he was speaking as a private citizen. I mean, historically, again, this is recounting the former Prime Minister by that stage conversation with the Palace. He rehearsed what had happened, the withdrawal of his commission, the passing of supply and the votes of no confidence in Mr Fraser and of confidence in the member for Werriwa, which had been passed by the House of Representatives. And now that supply had been passed, he should be recommissioned. So these are petitions from now, the former a private citizen, as Mr Whitlam described himself. He spoke calmly and did not ask me to make any approach to the Queen or indeed do anything other than the suggestion that I should speak to you to find out what was going on. So very fascinating stuff. I mean, it's an understatement, but this is what we're seeing in this release today. The second half of this letter, so page 2 of the same letter, again, as we go to that issue of involvement of the monarchy, the intervention, Sir Martin saying, if I may say so with the greatest respect, I believe that in not informing the Queen what you intended to do before doing it, you acted not only with perfect constitutional propriety, but also with admirable consideration for Her Majesty's position. So this is what is in front of you today. This is what's in store for all of you that are going to go through these 1,200 pages and look at the full context, the development of the conversation, the nuances, read between the lines, but these are the sorts of revelations which are in this release. The other thing I think about these documents, there's one other thing here. I almost forgot to mention this one. On the 20th of November, Sir John then wrote a much fuller recount of everything that went into his decision. For my layperson's eyes, it reads very much like quite a deliberately formulated judgment, in fact, being handed down to a full exposition of what went through his mind leading up to that point. One thing that is noteworthy amongst every other paragraph on that document is that the issue of why didn't the Governor-General tell the Prime Minister in advance that he was going to take this course of action and give Mr Whitlam one more chance to take action himself. So this is explained in this letter. And, Sir John says, history will doubtless provide an answer to this question, but I was in a position where, in my opinion, I simply could not risk the outcome for the sake of the monarchy. If in the period of, say, 24 hours during which he was considering his position, he advised the Queen that I should be immediately dismissed, the position would then have been that either I would be, in fact, trying to dismiss him, whilst he was trying to dismiss me, an impossible position for the Queen. So it's an insight into Sir John's rationale, Sir John's thinking as the Governor-General for why he did what he did, and this is his explanation to the Queen as to why he took the action he did. Again, fascinating stuff. So that's a full, lengthy letter again sent on the 20th of November. Finally, the last one that I've just put up here today is well after the event. This is the 7th of November 1977. This is already in the public domain. but this is in the collection today, but it's a transcript of his farewell speech. Basically, he's coming to the end of his tenure, which he also provided to the palace as part of his ongoing correspondence. May I say that the correspondence between Sir John and the palace continues with the same volume, the same frequency after the dismissal. There's plenty to read in that, plenty to research in that. It becomes a lot more reflective at that stage, of course, but nonetheless, the discussion between Sir John and the private secretary is fascinating stuff, and it tells just as much about Australia's history as the matters leading up to it. Look, and I simply put this up because Sir John did actually deposit these papers so that they could be made publicly available one day. And he reflects upon that at his farewell speech, as saying that the judgment of history in our democracy can be relied upon to provide an impartial final assessment. My own personal writings and archives will be available for history, some not for a long time. Well, today, that day has finally arrived. He then goes on to say, I shall bear in mind that people are entitled to as full an account of the historic happenings of their time as is possible, and as soon as is fitting. But there will be many factors to take into account. And I just put that in there as perhaps as the National Archives of Australia. Again, I acknowledge the work of Professor Jenny Hocking to bring us to this point, but I also have to acknowledge all of those that do choose to leave their records for public posterity in institutions like the National Archives, because today we are enjoying the legacy of that deposit in full, without redaction. Look, I just want to say there have been so much written about this period of Australian history, about the dismissal. What makes these records so important, though, is that these are not like a publication or an essay or an oral history of somebody looking back at the past and sort of speaking with the benefit of hindsight. These records are truly contemporaneous records. These letters were written by people in the moment who didn't know what was going to happen tomorrow. So they are as good a primary source as you're ever going to find about such an important, pivotal part of our history as this was. They were, as I say, in the long run, Sir John anticipated they would become public, but none of them were written on the day with public consumption in mind. They were written as private and personal and confidential correspondence. So they really do see and provide a great insight as to how the Governor-General saw his role, how he dealt from his office with this crisis, this constitutional crisis. And again, I hope that it will illuminate us all in Australia about what is a constitutional monarchy, how does the Constitution of Australia work, how does our democracy work, how does the Parliament work. So finally, I would like to start, first of all, I'd like to thank the staff at the National Archives. As I've sort of said in the past, perhaps not publicly, this whole journey to get us here today has, of course, generated a lot of, at times, quite heated discussion and heated commentary, and lots of commentary floating around. And I think a lot of it's been directed upon and commenting upon the role and the function of the National Archives. What is the National Archives? How should we function? What should we be doing? And what I hope is that this event today, to talk about our role and, of course, to show these records, has gone some way to perhaps enabling all Australians to understand what this national institution does, the fact that we have to remain a trusted and lawful institution, and the work that we are committed to do to actually make public records available for public access. And with that in mind, and before we go to Q&A, I'm very now pleased to release, without redaction, in full, the Palace Letters. Thank you very much. Thank you. That's the problem with these COVID things. There's nobody in the room, so the applause is so quiet. So look, we are very happy to have questions and answers if I've left something out that I should discuss. And we have microphones so that our people streaming can also hear the question. I'll ask Michaela or Louise, are you going to do the marshalling?
Hello.
Oh, yes, thank you.
Rod McGurk from Associated Press. How many letters were there? I've heard 211 and 212. And also, what's the time frame between writing a letter and it getting to Buckingham Palace? What's the process there?
Do you know what? I don't know with 100% certainty. I believe, having read some of the letters and references to, I didn't get this in the bag in time. I don't know whether that meant the diplomatic bag, whether it's customary to, at the time, or indeed if it still is, I have to confess, for this royal correspondence to be delivered by diplomatic pouch through Australia's diplomatic network. I imagine that was the case. So honestly, I don't know. That would be an interesting thing. And then the answer to your first part of the question, how long did it take? Back in the 1970s, you know, before, I don't know, imagine we had fax machines by then, but without email, yeah, these things were going, as you'll see, they were going by delivery.
So there wasn't electronic.
There's a couple of telegrams in the collection, so that there are some urgent telegrams that have been sent. I don't recall seeing a single fax. Who's old enough to remember fax machines? Thank you. Yeah, telex, yeah. So in terms, and you saw, you know, a letter going on the 11th of November, something coming back on the 17th of November. It was sort of, it was that era, you know, of communication by post. Yes.
Thank you. David Crowe from the Sydney Morning Herald and The Age. You said that you've released these without unredacted. Was there any request made to the National Archives to redact any part of these letters, either a request from the Palace or from Government House or from the federal government? That's question one. And the second question is, it's been a long journey to get this disclosed after Jenny Hocking had to take court action to do that. There's a lot of pressure on the archives funding. Was it wise to have to spend so much money, I think up to $2 million, in the courts to oppose the release?
So in terms of the court, I have to make decisions according to law, right? As I've said, there's no way I can do anything else. If the law says these are not Commonwealth records, then they're not Commonwealth records, and I have to uphold the agreement that we entered into with our depositors, or I have to uphold the law as it applies to Commonwealth records. Having made that decision, I'm accountable to the public. I cannot then say, that's it, I've made my decision, everyone rack off. I am accountable. Normally, it's before the appeals tribunal that we go, and the appeals tribunal has a forensic look at my decision processes and has the power to set aside those decisions. In this case, it was the federal court, and the decision was upheld in the federal court, but of course, I can't not go to court. I mean, that would just be me avoiding public scrutiny. On the other hand, to say, well, you know, why don't you save a bit of money and just do something which is not lawful, and that'll, you know, put that money back in your budget to do something else. Well, I can't do that. I mean, I can't avoid legal accountability for the purpose of saving money. So, you know, it's the cost of being a public institution. You have to face the people. You have to face the court. And this process, you know, I think Jenny Hocking is I'm going to stray into dangerous territory here. You know, there's a lot of discussion around the world about how public access should be given to government documents. At one end of the spectrum, there's Ed Snowden, right, who I do not, you know, reckless, irresponsible breach of trust. At the other end, you have people like Jenny Hocking who use institutions, who use the law, and today we are lawfully seeing the release of these records. So that's my answer. You know, I have to do things by the book, I have to be accountable, and I have to, you know, reveal all of our workings to the institutions.
There are redactions?
No, I'm required by law, and I do this, to consult with relevant agencies. The decision is my officers, supported by my staff, my expert staff. So no, this was all done according to the exemptions in the Act. Let's also not forget these records are, now that the High Court has said they're Commonwealth records that are 45 years old. You know, the sensitivities diminish over time. You know, this is the thing. It's usual to see more exemptions in recent records where some issues are still live. Records which are 45 years old, you know, the law is the law, and I objectively and neutrally apply the law, and hence there are no exemptions. Sorry, a question. So we'll go to Karen and then up the front. Thank you.
Hello, David. Karen Middleton from the Saturday paper. I'm just wondering if you can tell us about what process, if any, there's been about contact with or correspondence with the Palace in the wake of the High Court decision. I realise there might be limitations on what you can talk about in relation to the content of any correspondence, but what's the process been for notifying Her Majesty and getting any response from the Palace?
Well, the High Court's decision was quite specific, that these are to be treated as Commonwealth records. Now, under the legislation, I then go to the person authorised, to the responsible the person authorised by the Minister who has responsibility for these records. So my principal point of contact is with Government House. And then, of course, we seek advice, as you'll see when the records are open. There are lots of other issues in there, so we also talk to other, administrative people like, Foreign Affairs to make sure that there are no foreign relations which are going to be there. We look at privacy issues. And there are some personal details discussed in these letters, and so, of course, we have to give consideration to privacy. But again, given that they're 45 years old, given the balance of public interest and personal privacy, we have to give consideration to those. So what I do as determined by the Archives Act, and that is consultation across the Commonwealth of Australia principally. So I haven't had any direct discussions with the Palace over this.
Do you know what the process is, and has there been contact with other foreign governments as well?
The process is, have there been contact with other foreign governments on this? I haven't, no. But again, our consultation across the administered areas across government, we reach out to those with expertise to do that, and we rely upon that advice coming back to us and then to me to make these decisions. But again, in this case, there are no exemptions. Normally that becomes a more heated discussion when there are exemptions, but in this case there are none. Yes, up the front.
David, Shane Wright from The Age and SMH. Just a few quick questions. Have you worked out the total cost of going through this process, including the High Court? Are you going to have to seek extra funding from the government because the Archives budget is under pressure? And just on a separate issue, does the High Court ruling affect the holdings that the Archives have from any other Governor-General?
So, look, no, there's no, on the funding issue, and I know that the figure 2 million is, I've seen that reported as well. Honestly, I don't know what the cost is going to be. We're still tallying all of that up. But again, I'm not, I don't, that is the cost of being a public institution. Like, really, it's a part of doing business. If you're going to maintain public trust, you have to be accountable to the people. And the courts in Australia exist for this very reason. This is a good lawful outcome. So no, there's no. I'm not announcing today any sort of crowdfunding or anything else. Maybe we should have a bucket at the door if anyone wants to donate money. But no. The other part of your question in terms of implication of the High Court judgment. Look, the answer is yes, but I've been so focused on getting this done. So this has been 30 business days since the High Court decision. We just put everything into this case, and the High Court's, the decision, there was twofold. One is that this box of documents, those boxes over there are Commonwealth records, and get on now and reconsider Professor Hocking's application. So I've been focused on that. I do still continue to need to go through that judgment and have a look at how that impacts upon the other royal correspondence that we had. If any of you have read the judgment, the High Court deliberated for several months over that judgment, and the judgment is very, very detailed. And so I don't want to it would be foolish of me to be standing up and making too many pronouncements until I've had proper legal advice and a full and proper understanding of what it is. But I think we've developed today that when the law is clear, our action is clear as well.
So there are more boxes like that sitting in back shelves?
Yep, no, we do. Yep, yes. Not on a back shelf. They're in carefully preserved conditions, right, under the National Archives of Australia. Yes. Over there.
Good morning. Thank you for this. My name's John Carmody from Sydney, and I'm here also as somebody who in the past has sought and been refused access to the documents. At the time, I proposed the same sorts of arguments as Professor Hocking did, so I'm pleased to see that the High Court has decided that we were right and the archives were wrong. But I want to ask two questions, but the first one has legal aspects, and I preface that by saying I'm a medical scientist by background and a historian. I'm not a lawyer, and you've just said you're not a lawyer as well. You said in your preliminary remarks that you felt obliged legally by the terms under which Sir John gave the archives to his papers to the archives and said that the final decision should be made by the palace. I might say that under British law, royal documents are officially defined as not public documents, so the palace may not have given a totally objective judgment in that. That's not part of my question. My question relates to the way the intentions of deceased people have been interpreted by Australian courts, and they've overridden those. I wonder why you felt that it was important for you to stick strictly to the terms under which Sir John, by then deceased, had given these documents to the archives, and why you felt obliged to accept him, because I happen to know that the family are quite insistent, Sir John's family are quite insistent that they have always said yes when people sought access. So you were privileging the views of a deceased person over the views of his beneficiaries. So I'd be interested to know why you felt legally that was the right thing to do. The second question bears something to do with what David said. I presume you've had discussions with your minister apropos whether you should appeal against the High Court's judgment, whether you should expend further government money in objecting to this. I'd be very interested to know information that you feel able to tell us about the correspondence between, or discussions between you and Mr. Porter about whether or not you should take further action.
So let me go to the first question first. I work with what's in front of me. So what I had as my instructions that I inherited when I took office here was a clear instruction from the depositor, Sir John Kerr. Now, I accept your remarks that the family has always maintained they wanted these things to be... That was never in front of me. You know, can I say that? With full respect to Sir John's family, I've never been approached by Sir John's family, and any time that I've been in office here, it's saying, Director General, can we please have these things released? That has not been in front of me. So, you know, legally, therefore, and then with a legal view, upheld by the Federal Court, I'm not going to scandalise the Federal Court, neither am I going to scandalise the High Court. Federal Court saying, OK, look, there's not Commonwealth records. Under the Archives Act, you enter into arrangements with the depositor, etc., etc. So that's why. So I can say that was never put to me, and that might have resulted in a different story. Look, on the other side, I won't go into detail about advice between myself and my minister, the Attorney General, other than to say that, of course, the Attorney General has been kept up to date with all of our work on this, following or leading up to and following the High Court case. Perhaps the gentleman over here first, and then we'll come back to the second. Oh, that's it. Yep. And then over here. Sorry. So yep.
Hi, David. Chris Knowles here from The Guardian. Thanks very much for that. You've frequently described the archives as a pro-disclosure organisation. Two questions on that. Do you think that is the way the public perceives the archive now after this case? And secondly, do you think the Archives Act and the funding available to the archives allows it to fulfil that role properly?
Look, you're never going to meet a public servant that says, I don't want more money, all right? I mean, of course, you know, we all want more money. I absolutely appreciate the fiscal constraints around all entities across government. You know, efficiency dividends are applied across the board. So that's all I can say. Of course, I'd love to have more resources, more funding to do more of the work that we do. As I say, we get 40,000 requests to open, to declassify records every year, 40,000. We can do about 20,000 at the moment, I think. So, there are backlogs. And look, I haven't, I've never shied away from the fact that I wish we could do better. What I get defensive about is being accused of being secretive, whereas in fact I should be accused of being slow. It's, and it is, so if people, there are reports of, people waiting 8 years to get something out of the archives. Well, that's not us saying, 8 years ago, no, it's refused, you're never seeing that document. It's waiting 8 years for that thing to get down there. Now, I know it's a fine point. That's very cold comfort for a PhD student or someone with a deadline. I get it, okay? I do not shy away from that. But to your point about being secretive, I hope events like today and what we do each year with the cabinet release and what we do with every day of the week, in fact, opening up documents and releasing documents. In the last complete year that I have reporting on from the 2018-2019 year, we released about 315,000 records, okay? And just, I think, less than 1% of those were withheld for national security reasons, for personal privacy, for confidentiality, etc. Less than 1%. 96% are released without redaction. Okay, so and that statistic hasn't changed in the time I've been here. I cannot see a trend of increasing secrecy. I do see a trend of increasing demand, and I love it, because the archive, we keep records not because we love keeping them. As I say, we don't keep records for Jesus, we keep records for the people of Australia. We want to release them. But it takes time, it has to be done carefully, it has to be done according to law. So that's, they're the sort of issues that we are dealing with. I take it very seriously. We are established for the purposes to make records publicly available. The law dictates where those exemptions exist. As I've said earlier, those exemptions are tested in front of the tribunals, in front of the courts, and on occasions like this we see how that can sometimes turn those decisions around. Yes, yep, Troy at the back, and then to this gentleman here. Yep.
Thanks. Thanks for your presentation, David. During the court case, the archives made available some correspondence that had been received by Government House, which then referred to correspondence they'd received from Buckingham Palace about these letters. Are you able to make available any other correspondence that you've had either with Government House or with Buckingham Palace about these letters?
Could be, Troy. I'll have to get back to you on that. As I was saying a bit earlier, we've been so flat out focused on this box of records here. I do need to go back and study that judgment and just have a good look at how that impacts upon the treatment, the proper treatment of those other records. So if I can take that on notice. I think this gentleman here on the question. Oh, sorry, then we will get back to you. Yes, I do apologise.
Thank you. Philip Benwell from the Australian Monarchist League. Are there any letters in this collection directly from the Governor-General direct to the Queen and from the Queen direct to the Governor-General?
I believe there is, directly to the Queen. And I'll get the number wrong, but I believe that there is. I'm recollecting at least one or two were addressed directly to the Queen, addressed Her Majesty. By and large, though, most of them go through, as you would expect, in an organisation like the Palace, they go through the private secretary. But there are one or two to him. You'll have to have a look. I don't, unless anybody else in the room, I don't recall if there is something directly from Her Majesty back to Sir John. I don't think so. But I may be wrong on that point. You can correct me. Yes, this gentleman. Yes.
If you could just explain when you're looking at what should be exempted or what not, what sort of things do you look for in documents such as this?
Look, it's information, and this is for all of you who are fascinated by reading legislation. I refer you to Section 33 of the Archives Act. So there are exemptions there which and a record is exempt if it contains material the release of which might be adverse to the national security interests of Australia, to Australia's foreign relations or relations with a foreign entity. And I point out the Queen is the Queen of Australia. Her Majesty is not a foreign entity. There are provisions in there for personal affairs. You know, if it would adversely affect the personal affairs of any person living or deceased, if it would adversely affect the professional affairs of any person living or deceased. It goes on to protect. There are other things there, like protecting witness. You know, people are in a witness protection regime. You know, we can't do that. There are other protections for census material. Can't be released until 99 years after the census. These sorts of things, they're all laid out there. But by and large, it's to make sure that you know, issues like national security, foreign relations of Australia are protected, and to protect the rights of individuals. Now look, you'll see in here, and I may get questions about some of the personal information which is released in these documents, but I was minded that it is 45 years ago. They were included in the records because the Governor-General wanted Her Majesty the Queen to know about this. They are very much for that reason public records, and in my judgment there's no adverse effect on the personal affairs of any of the individuals mentioned. Yes, are we out of time? Okay, we have one more, perhaps up the back. Yes, the gentleman up the back. Thank you.
Thanks. Sorry, just two quick questions.
There's only time for one.
The first one
You'll
being,
only get one answer, so choose.
when you were negotiating with Professor Hocking on the release of the letters back in June, you were meeting with her at the same time you released a statement saying it would take up to 90 days to release the documents. So would you say you acted in good faith with Professor Hocking the whole time since the High Court judgment? And the second one being, did a lack of resources have any effect on the delay between the judgment and today?
Yeah, look, I didn't actually say that. You know, I know what the legislation says that if I haven't made a decision within 90 days, it can be appealed to the appeals tribunal. Right? It doesn't, you know, it's an odd sort of construct in the legislation. So I never actually said, I'm going to take 90 days or whatever. What I was trying to say was I'm actually focused on getting it done as quickly as I can. Okay, I wasn't going to drag this out, playing some new game about legislation and all the rest of it. And you're right, you know, Professor Hocking and I had good discussions about this. To go through this number of documents, and again, we hadn't examined these documents under the Archives Act prior to the High Court decision, because prior to the High Court decision, after the Federal Court decision, they weren't Commonwealth records. They were never looked at that way. So what we did is move as quickly as we can to go through. Now, even though a lot of the pages are press clippings, right? I mean, the press clippings are public. It's not like we're examining what the journalist said in 1975 and seeing whether it should be. But nonetheless, you look at the press clippings and just make sure that there's a reference in there which is confirmed in the letter or, you know, whatever. So you still have to look at every document. But that's why we could get it done in 30 days, which is a pretty good, short period of time to get through a release of this nature and of this scale and scope. What was your other question?
Just in terms of you releasing the statement saying it could take up to 90 days.
Oh yes, that's right, I did answer that question.
Professor Hocking at the time.
Yes.
So she was quite surprised to learn of that delay just after she had been.
Yeah, that's because the reporting was a bit garbled. I didn't say I was going to take 90 days. I was trying to, again, as I do foolishly, try and explain the Archives Act to a newspaper journalist who's not always interested in what the Archives Act says, I have to say. All right. So, well, thank you for those questions. I'll now hand the podium back to Louise Doyle. Thank you all very much. Thank you. Oops.
Well, thank you, David. And enlightening, I'm sure, but exciting in terms of now the opportunity is to do some forensic work on those records. I'd now like to invite you to view the facsimiles we have of the Kerr Palace Letters on this side of the room and the original box that they came from, opened by the Director-General, in fact, a couple of years ago, with a notice on the top of the box saying only to be opened by the Director-General of the National Archives of Australia. So over the last few years, yes, and now finally forensically examined by our declassification team. Available for viewing, to photograph and to film. And on this side of the room, we have, to put into context, sealed boxes and sealed material of other palace letters, as we call them, from former Governors General. So there is a context here. And as David did say, we'll now be having a look at the judgment again and looking at how these other palace letters fit within the context of that judgment. There are media bookings one-on-one. If you have registered to have an interview with David Fricker, please see Michaela Forster over here with her hand in the air. Don't forget to hand sanitise on your way out, and thank you all so much for being so COVID safe within this space and respecting social distancing. There is a USB for you to pick up with digitalised records, copies of the records for you to take away. And lastly, you're welcome to enjoy some morning tea out in the Central Hall. Thank you so much for your patience and for being with us today for this terrific historic event. Thank you.